Good morning, all. Welcome to Taub Live, where we cover law, money with a touch of snark. So let's talk about the law. Yesterday was a disaster for Donald Trump in many courthouses across the nation. I want to focus today on two top areas. First, yesterday, a federal judge in New Hampshire, less than 2 weeks after the Supreme Court shut down a nationwide injunction to block Trump's birthright citizenship order, within 2 weeks of that, this court went ahead and granted a nationwide injunction to block that hideous birthright citizenship order. And I just want to make clear, don't be confused. This federal judge in New Hampshire was not defying the Supreme Court at all. In fact, the case that was filed on the very day the court's decision came down on June 27th was designed specifically to drive right through the loophole, to shoot right into that loophole that the Supreme Court said existed. And I shouldn't even call it a loophole. So I want to make clear to you that what happened yesterday, and I'm going to describe it for you, in New Hampshire was a victory for all of us who don't want Donald Trump to redefine U.S. citizenship, to exclude birthright citizenship, which is baked right into the U.S. Constitution, which the Supreme Court has upheld again and again and again. What we want in terms of what makes sense, in terms of what is the rule of law, in terms of a vision of a welcoming, inclusive America is as follows. If you are born in the United States, you are a citizen here, regardless of where your parents are from, what their nationality is, and so on. That has been the law of the land, clearly, unequivocally, since the end of the Civil War, right? We're talking about almost 150 years. And there have been Supreme Court cases, as I mentioned, again and again and again, making clear that that is the law. So if you feel confused why I'm saying the judge yesterday did not violate a Supreme Court ruling, let me explain to you. The big difference is the previous cases were brought by organizations and individuals on their own. And the judges looked at these cases and said, wow, that executive order is unconstitutional and it's unlawful in other ways. So I'm just going to say it can't go into effect across the board. And what the Supreme Court had said on June 27th is it doesn't work that way. You can't rush into court and get a nationwide injunction in an ordinary case. And so the topic came up, and you might remember this. What about a class action? What about that? And the government didn't commit in that case, but now lawyers have immediately begun, as soon as the case came down, again, on June 27th, 2 Thursdays ago, these lawyers designed and brought class action lawsuits. So it's a case where you say, hi, I'm a person who is harmed by this birthright citizenship law. Like, I am someone who I'm not a U.S. citizen, and neither is my husband. And I just gave birth to a child here in the United States. And I applied for a Social Security card, and I don't think they're going to let my child be a citizen. That kind of person would bring a lawsuit. So if that's me, it'd be like Jennifer versus the Trump administration, right? And I'm just saying that generally, right? Other departments in it. And I would be saying that I am bringing this lawsuit on behalf of myself and other individual people similarly situated. So that is what happened. And yesterday, a federal judge in New Hampshire said, number one, I am going to certify that class. We don't know who all these individuals are yet. That's how a class action works. Number one, I'm going to certify that. And number two, I am going to grant a nationwide preliminary injunction blocking what appears to be this unconstitutional law. So that's what this judge did in New Hampshire. But what the judge did, he also said, I'm going to put this on hold for 7 days. Can I do this right? 7 days. So that the 7 days, I'm trying to show you. Yeah. So the Trump administration has an opportunity to appeal. So we are going to quickly see some action on this class action. This is huge. This is huge. And so I want to first share with you an interview from last night with Norm Eisen, who was the lawyer, one of the organizations. He's a lawyer there who helped bring this lawsuit on behalf of these individuals. And Norm Eisen is also a lovely person who worked in the Obama administration and also has, as you may know, launched with Jen Rubin and others, The Contrarian on Substack, a highly successful newsletter, and good for Jen Rubin for quitting the Washington Post, which has lost its mind. So let me share this with you because Norm Eisen deserves to crow and celebrate about this. So let's do that first.
I have to agree, Chris. As you know, my parents came to this country as migrants. My father fled the Holocaust in Europe in 1940. He came here as an undocumented migrant. He earned his citizenship by serving in the U.S. military, fighting autocracy and authoritarianism. And I was always taught exactly what the judge said, that being an American, the idea of America. However, we may be reaching towards a more perfect union as a country, in the words of the founders and framers. The idea of America is so precious, and the citizenship that goes with it for all persons born here. So for Donald Trump to try to rip that away from some babies born in this country is an insult to the Constitution, to all of our families, Chris. Other than the Native Americans, we're all migrants to this.
Okay, so I'm going to blow this up for you. You can see what Norm is showing you here. Section 1 of the 14th Amendment. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the states wherein they reside. Okay, let's continue listening to Norm.
Land. The judge got it just right. And just as important, he got it right and he did it fast.
Got it right and he did it fast. Now, I bet you want to know two things. What exactly, shorthand, why did the judge make this decision to issue this preliminary injunction? And I bet you also want to know, oh, come on, Jen, why do you think this is actually going to survive the United States Supreme Court? You're probably thinking this court will find another reason to put this on hold or say that the class certification was wrong or that you can't use a nationwide injunction. So I'm going to get to that. But first, I want to share with you and give someone else some credit, which is my friend George Conway. And the day the decision came down, it was called Trump v. Casa. The day that case came down, we were here together, right? I was here. We were live streaming together. Before it came down that morning, I was showing you the oral argument in that case. And when it came down, I walked through the decision with you. And a lot of us, myself included, were very upset because we thought, the court should have just taken up this case on the merit, should have just decided, in a case that is so patently unconstitutional, where this executive order is clearly violating it, why couldn't the court just jump in and shut it down? That's what I felt. So, and just to remind you, that case was just about whether a nationwide injunction was appropriate in an individual case and not a class action lawsuit brought in a specific, district court, not a class action like we were talking about. So let's listen. I'm going to share with you that very day on MSNBC, Melissa Murray, law professor from NYU, who I love, George Conway, my friend who I love. It's not that I could call Melissa my friend. I've only met her once at an academic conference. But anyway, fabulous, very smart people. getting in this debate. And why I want to share this with you is this gets to a prediction right here of will the court allow this? I want to side with George because I want to believe that we actually can stop Donald Trump's ruthless and unlawful executive orders, right? I think earlier this week, I was telling you that there was a class action certified in a different case and how glad I was about that. Well, this is even bigger. And so I want to share this debate with you. We'll watch it together. It's not the full debate, but I'm going to start with this part. Melissa first spoke about the decision, and then George speaks about it, and then they kind of get into it a little bit. Let's play this.
Justice Ketanji Brown Jackson, in her dissent, are saying that this leaves everyday people to effectively fend for themselves when it comes to government infringements of their rights. How do you see it?
I disagree. I don't think this decision is a big decision, a big significant decision at all for most of the people watching out there.
Oops, sorry,
an interesting
guys.
decision for students.
I'm going to rewind this for a second. I want you to spend your time watching Melissa Murray's face, because if I disagree with someone, it is so hard to stay poised. And she only does a few, arched eyebrows. She doesn't have what I do, which is a very loud face. And I would have been jumping out of my seat to interrupt, but she waited. Let's watch again.
In fact, Justice Ketanji Brown Jackson, in her dissent, are saying that this leaves everyday people to effectively fend for themselves when it comes to government infringements of their rights. How do you see it?
I disagree. I don't think this decision is a big decision, a big significant decision at all for most of the people watching out there. I think it's going to be an interesting decision for students of the federal rules of civil procedure and class action procedure, but I don't think it's going to have much of an impact. And I think the decision is actually correct, much as I agree with everyone that what the administration here is trying to do to the 14th Amendment, Section 1 is pretty much it is a depraved and insane interpretation of the 14th Amendment that only the likes of President Stephen Miller could come up with. I mean, essentially what the court this is the equivalent of going to the DMV or going to the passport office and showing up at the window with your form and being told, no, sorry, you have to fill out a different form. And the form's over there on the table and there are pens on the table and you have to just come back. And what happened here is Justice Barrett is absolutely right. This is not a traditional form of injunction. The way you get an injunction of the sorts that have been issued here is through a class action. And, I know that sounds burdensome. It sounds big. And I know, I practice class action law as a defense lawyer, and it's very, very difficult to get, to deal with class certification issues in a big case involving antitrust and securities and things where you have to hire experts and so on. This is the most pure form of class action, where basically it's up or down on the interpretation of a few words in the Constitution, which I think can't be interpreted any other way than the way that these judges and the plaintiffs have found it. And so what's going to happen here, the reason why we saw multiple lawsuits brought this afternoon is 10 weeks ago when the Supreme Court decided to hear argument on this stay application, everybody realized which way it was going to go. So they just wrote new pleadings that said, we're going to ask for a class action. And what's going to happen next is the courts are going to say, yeah, okay, we're going to certify class actions. And frankly, there is no basis to oppose.
Okay, so I'm just cutting this for 1 second. We're going to play it more. This is the legal part. We're going to dig into it later. He's saying there's no basis to oppose this kind of class action. Okay, let's keep playing. Here we go.
This certification of a class action here, because it is so simple. It's one issue of law. It's straight up or down. And we're going to have 4 law, and maybe not per very broad injunctions, maybe even nationwide, that are just simply going to be issued in class actions, which eliminates the problem. And so
George,
I think we're just going
sorry to interrupt you. Melissa
order.
has been vigorously shaking her head for a while.
Because George, you are wrong.
Okay.
You are wrong. And you know you are wrong. First of all, this case, Trump versus Casa, involves not just individual litigants, but also states as litigants. And you know, as a lawyer, that the federal rules of civil procedure do not permit states and organizations like Casa to present themselves as candidates for class actions. Federal Rule of Civil Procedure number 23 only applies to persons. So the idea that anyone could go forward forward as a class action is absolutely ludicrous, and you know that. This was the only remedy available to lower federal judges to rein in this particular administration. Now we are asking individual litigants to either go to every district court throughout the country to individually file suit or to alternatively launch a broad class action for which many of them don't have the resources. And right now, at a time when this administration has forced law firms to capitulate, further narrowing the availability of legal resources, the fact of a class action is going to be virtually impossible, and you know that. This is a devastating decision for the rule of law. It is a devastating decision for the rule of law. It is a devastating decision for democracy, and it is part and parcel of this court that has, for the last 2 years, facilitated this president in what has been an utterly lawless march through constitutional law.
George,
I admire you and I love you, and I agree with a lot of what you say, but you're wrong. Federal Rule of Civil Procedure 23B2 basically says this is exactly the kind of case where a class action should be certified.
Not
and yes,
with the state,
states
George.
can't ask,
Not with organizations like CASA,
fine,
George.
But there are individual. Excuse me. Individuals can bring large class actions here, and the states have every right to seek a relief that affects them.
Okay, guys, that's my kind of debate. And the bottom line is the proof is going to be in what the United States Supreme Court does here. Okay? So, did you hear them talking about Rule 23? I think you did. And you know how much I love my rules. You know how George also said, this was from June 27th, that the decision the Supreme Court made at that time would be interesting for students of civil procedure. Hello, how about professors of civil procedure? I teach civil procedure. I teach Rule 23. You know, you have no choice for a moment but to look at Rule 23. You knew that was going to happen here. You know, this isn't law school, but it's not your regular show. So we do have to take a look at that. So let's go ahead. I know you want to. Okay, here we go. That sounded really bad. This is actually consensual. You are consensually looking at Rule 23. So this is Rule 23 for class actions, Rule 23 of the civil procedure rules. And what I want to do is blow this up. But after I do, you can see what I'm looking at. Rule 23 talks about when one or more members of a class may sue or be sued as representative parties. Okay. And so let me just tell you what the standard is. When there are so many people who want to sue, this is one, the case is so numerous that joining all parties is impracticable. What does joining the parties mean? Here, let me just blow this up so you can actually see it better. There you go. Sorry, guys, I made it as big as I could. I'm going to throw this rule in the chat. Cornell's website is really good about statutes and rules. You might say, what is this? What is the authority for the rules of civil procedure? I think we've talked about this before. They're sort of indirectly blessed by Congress, drafted through a committee, blah, 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 blah. Okay. And it was the desire here was to standardize rules, the procedural rules in federal court. So let's look at this. So what does it mean that the class is so numerous? Well, what that means, my friends, I'm going to pop in here for a moment, is it's so numerous so you can't join people. Join people just means sue together. So let's say I wanted to bring a lawsuit against a contractor who worked on my house and then did some electrical wiring and part of the house caught on fire, right? I might bring that lawsuit on behalf of myself and my husband, right? For example. That didn't happen, right? Or let's say there were several people at a high school who, something happened something happened and they wanted to sue, let's say the principal or something, or a specific, let's make it a private school so it doesn't get complicated. They wanted to bring a lawsuit. So you could easily join together, let's say 10 people, right? That'd be easy. But what if there's more than 10? There are hundreds. It would be very difficult to allow them all to be witnesses in the case, right? For them all to have to respond to discovery requests. It becomes cumbersome. There's not a magic number, but there is some number when you can say this is so numerous that it would be difficult to join them. Not only that, you can't necessarily know who they all are when you're defining a class of people who are affected. So that is what numerosity means. Let's look at the next prong. And I know you're saying, didn't they say Rule 23B? Yes, they did, but 23A also applies. So the first step to being able to get permission to create a class action is there's so many people who could be, in this case, the plaintiffs, that it'd be impracticable to just have them all sue and be named in the lawsuit. Secondly, the standard is commonality. There are questions of law or fact common to the class. So in that case would be, the question of law might be, in this case, an executive order that says these children and their parents of these children are affected by, like the one saying you are not a citizen if you're born here, if your parents aren't, right? Okay. And then third, and the questions of fact have to be common as well. We can talk about that in a moment or not. And the third is the claims or defenses are typical. So this is called typicality. This goes to the question of the person who's bringing the lawsuit. So let's go back to me. I'm the woman who's just had the child. And are my claims that it's unconstitutional to deprive my child of citizenship, is that common? And then I'm claiming legally that it's a violation of the 14th Amendment, for example. Is that going to be the common kind of legal claim others I'm saying in my class would make, and so on? And then the fourth prong here is that the representative parties who will fairly and adequately protect the interests of the class. In other words, am I the kind of person who would protect everybody? You can have situations, this is not, in this case, that wouldn't even come up. Let's just put that. Okay. So types of class actions. This is the part that George was talking about, a 23B class action. So a class action may be maintained if Rule 23A is satisfied and if, and here's the choice. So 23B, you could have a 23B2 class action. So I'm going to blow this up. That's what we're talking about here. A 23B2. The party opposing the class, that would be the Trump administration, has acted or refused to act on grounds that apply generally to the class, so that the final injunctive relief or corresponding declaratory relief is appropriate respecting the class as a whole. That's the standard. That's it. Now, okay. These rules don't mean anything until you see how courts have decided under them. What George was trying to say, and what Melissa, they were arguing about is, in this instance, unlike the CASA case, which was a case that an organization brought, right, or states brought, here we have individuals, like I was using an example of me, it wasn't me, but other moms, etc., who are bringing this case, and not organizational parties. That is why a 23B2 class action would be appropriate. I hope you're happy with this, okay, guys, because I side with both Melissa and George. I want George to be right, and I fear that Melissa is. Now, I want to take one peek at the court's decision. This is New Hampshire court, so you can see how this played out in the opinion he wrote. First, he put out an order yesterday morning saying that he was going to certify the class and putting this preliminary injunction nationwide on the order getting rid of birthright citizenship. I want to share with you now the decision, and then we'll move on to some other stuff, okay? I promise. But let me just pull another screen share here, and we get to our decision. Let me just see if that's working. We do. I pulled this up right on the page of where it said class certification, just so we could have a lot of fun with this, because this is the real question here, right? I just want to be like as clear as I can. I'm going to get to why this order is patently unconstitutional in a moment, because that matters. But we all know the arguments for why this is unconstitutional and unlawful in other ways, this trying to strip away birthright citizenship. We know that. And every court has said so. So the key thing here ends up being this procedural question. Can this class be certified or not? So I want to pull this up for you to see the court's reasoning here, because this is going to be the name of the game. And I also have to tell you, when I first went to law school, this kind of stuff infuriated me. I'm going to pull this for, do I want to do that? No, I don't want to do that. I'm just going to stop sharing for one moment though. This kind of thing infuriated me. When I took civil procedure, I wanted to scream in class. I was so angry when there were procedural obstacles to justice. And I was like, why? And I still kind of am like that, right? Like, why couldn't the court just rule the right way here? Why all these hoops? Well, the answer is because we don't want nationwide injunctions to be issued against things that we think are constitutional, just because an aggressive right-wing plaintiff, for example, challenges something and finds a judge that has been placed in a specific court that they're going to sue in who will say no to everything, right? We've talked about that before. Okay, so let's go back to this case so we can see what I'm talking about here. Okay, so this is the class certification part of the decision where the court says the court grants provisional certification, but to a narrow class and proposed by petitioners. The certified class includes only those persons to whom the executive order denies citizenship. It does not include their parents. Okay, this was smart of the judge. This judge wants to think about this surviving. Okay, so the petitioners have moved for certification under Federal Rule of Civil Procedure 23B2. Guys, we were just looking at 23B2, right? Now, the judge is going to quote it. Rule 23B2, certification is permissible only, and they go through the 23A part, the class, the numerosity, the common questions of law and fact, the typicality, right? And the adequate representation. We just did that. I wasn't lying to you. And then in addition, the proposed class must satisfy at least one of the three requirements in 23B. And they're citing the Walmart stores case on this. That's a Supreme Court case. And here, the petitioners seek to certify a class under 23B2. I just read this to you, but let me tell you, the court said the same thing, which requires the party opposing the class has acted or refused to act on grounds that apply generally to the class, so that the final injunctive relief or corresponding declaratory relief is appropriate respecting the class as a whole. So injunctive relief might be saying you cannot enforce this executive order. A declaratory relief would be this order is unconstitutional. Now, so the court said what the rules were, but what is the analysis here? Because you and I can read the rule and say what it says. Let's listen to what this New Hampshire judge said about applying that rule to these facts. Both the burden and quantum of proof under this standard are familiar. The burden here rests with the petitioners, right? These are the people wanting to certify the class. The required quantum, that means amount of evidence, is proof by a preponderance, right? That makes sense. Not beyond a reasonable doubt. This is a civil case. And this is a quote from this Supreme Court Walmart decision. Of course, you want to quote a Supreme Court case. Rule 23 does not set forth a mere pleading standard. A party seeking class certification must affirmatively demonstrate his compliance with the rule. And then it is sufficient if each disputed requirement has been proven by a preponderance of the evidence. Okay, so they go through this, and let me just say, they know the standard. So let's go to the analysis. The court grants provisional class certification, right? And this is, but doesn't adopt this full class, only adopts for the children. Fine. Great. So they go through and explain. Narrowing the class sharpens a focus on the specific injury for which relief is claimed, the denial of the children's right to U.S. citizenship. This is a cognizable injury applicable to all members of the certified class. If a child is denied citizenship because of the executive order, he or she will suffer the same injury as all other children subject to it. Although other harms may follow from the denial of citizenship, they are not the subject or the claims of requested relief. Okay, so what is the class that's been certified? All current and future persons who are born on or after February 20th, 2025. Why that date? Because the order was to take effect within 30 days. He signed it on the 20th of January, hence February 20th, I think. All current and former future persons who are born on or before February 20th, 2025, where one, that person's mother was unlawfully present in the United States, and the person's father was not a U.S. citizen or lawful permanent resident at the time of said person's birth, or two, that person's mother's presence in the United States was lawful but temporary, and that person's father was not a U.S. citizen or lawful permanent resident at the time of said birth. I'm not going to go through the whole decision, but you can see the court discusses numerosity. The court says normally if there's more than 40 plaintiffs, that's numerous enough. Okay. So what else do we have? Commonality. I mean, the court basically goes through all of the standards here. I want to go through the last thing after adequacy of representation. I want to get to the 23B2 certification. Okay. So this is the analysis under 23B2. And they keep repeating that rule again. The party opposing the class, that would be our government, has acted or refused to act on grounds that apply generally to the class, so that final relief or final either injunctive or declaratory relief is appropriate for the class as a whole. Okay, so here the court let me just go on and on. Here we go. Because enforcement of the executive order would likely constitute unlawful behavior towards the entire class as limited by the court, right, which would mean the children, and because a single injunction and declaratory judgment would provide complete relief to every member of the class, this class fits comfortably into Rule 23B2 category, right? Fine. Now, they talk about the respondents, the government, that's making arguments for why this class should be not certified. I think you want to hear what Donald Trump's team has to say. They make several catch-all arguments against class certification at the early stage in the litigation. The court rejects these generalized contentions in favor of the petitioner's suggested course of action. So the Donald Trump administration objects to provisional class certification and claims that that shouldn't be. The court says no. The court says that the judge says that he has no hesitation in determining this situation warrants emergency injunctive relief and class certification. They say that the judge said that the Trump's proposed course of action would reverse a nationally known and recognized government policy in place for over a century and affecting thousands of families. Okay. He rejects premature certification and on and on and on. Now let's talk about the nationwide class. Similarly, the Trump administration also contends that a nationwide class is not appropriate, and they cited that CASA case from June 27th. And they're claiming it's an end run around this universal injunctions. And the Trump administration said these issues need to percolate, and it's not appropriate for a class certification. Okay, so the court says no. At no point in the brief do the petitioners request a nationwide class, right? That's not, they're just saying as long as the court adheres to the requirements of 23, the class may include people in all 50 states. Okay, great. So now we get to the merits after this. This is likelihood to succeed on the merits. And this is, I'm scrolling down. This is where we get to this question we've talked a lot about. This is whether there would be, whether they're likely to succeed on the merits. Here we're saying this is clearly, that every district that has federal court that's looked at this has said this order is unconstitutional and the plaintiffs would likely succeed just on the law. And the court says basically there's a strong, refers to CASA, the district court order saying the executive flouts the plain language of the 14th Amendment to the U.S. Constitution. This conflicts with binding Supreme Court precedent and runs counter to our nation's 250-year history of citizenship by birth. Okay, great. So it's all of our nation's history of citizenship by birth, but we have the 14th Amendment that made it clear. Now, what about irreparable harm? They talk about that why they would be harmed. And again, I'm going to stop here now, almost. One other thing that happened is that they have to issue a bond. So $1 is what the plaintiffs have to pay in order to secure this injunction. So I'm going to stop sharing here. I think you get the idea. So what you now know is that we are in a position to find out who's right, Conway or Murray. Again, hoping it's Conway, fearing it's Murray. I'm hoping this certification of the class of children who have been or could be, who will be born and subject to this executive order are protected. Right now, it looks like there's 7 days before that goes into place. We will see what happens here. Okay, guys. So why are we even talking about this? This is because it seems to me like the entire Trump administration agenda is focused on dividing all of us. And the central focus here is blaming immigrants, not just immigrants who are undocumented, not just immigrants who are here temporarily, not just immigrants who are naturalized, not just immigrants who have birthright citizenship, right? But anyone here who they don't like, they're going to try to treat as if we are not as worthy and we don't deserve to be considered citizens. We saw this with J.D. Vance the other day, claiming that someone who came to America after the Civil War, whose family did not fight in the Civil War, and he's only using here white people. He's not including people who were enslaved or free blacks who fought on the side of the Union. No. He's saying that because he was referring to people like Zoran Mondami and maybe people like my family who came here after the Civil War, immigrants, that if our parents didn't shed blood here, we're not as good. This is just utter nonsense. It goes back to the whole blood and soil Nazi ideas identification. It's also obviously very patriarchal. Now, so this is Donald Trump's agenda. And that is why I'm now going to turn at this moment to another ICE raid that happened yesterday in the evening, our time on the East Coast, around 6 o'clock, around 3 o'clock in the afternoon. And this raid and a standoff lasted well into the night. I think it was at least over 5 hours because I was looking at some of the footage of this. I'm going to show you first the news footage, and then I'm going to share with you some clips, one clip or two clips that I have seen on social media of people in the field. So let's first play this.
Showed up to vehemently protest what's going on here, and just in the last few minutes, Customs and Border Patrol helicopter has entered the scene here. They are landing in the middle of the farm as we speak. It does appear that they were not planning to be here as long as they have been, and so this helicopter that you're looking at here, guys, apparently just made a run over to Van Nuys Airport for some cases of water, which is what they're bringing into the scene here. So there are a whole team of ICE agents at the farm. There are other agents down there as well as the National Guard police standing guard and protecting Laguna Road as this enforcement action takes place right here, going into hour number 4 this afternoon. Again, a major situation transpiring here in Camarillo, and it does not appear that they were intending to stay this long.
Okay, so there were two areas in Ventura County. One was Camarillo, and I don't remember the name of the other one. I will share that with you in a second. And there were two types of farms that were raided. One was a cannabis farm, and the other was tomatoes. As I have found out, this whole area of the country, Ventura County in California, produces 20% of the strawberries we eat. I want to share with you what was going on. Children were panicking. I'm going to give you some close-up footage here. They were shouting, "Let him through," about a congressman trying to get through. And this was local resistance. This is from someone who posts as LA Taco, local resistance to military occupation of Carpintero, California. Let me keep playing this for you. Okay, there is so much more. So I want to do a little more sharing with you guys before we get to the end of the show in Crazy Town. Hold on one second. The way I do this, it is, these are like independent journalists here who are sharing this. So let me just get this for you. Okay. The way I'm doing this is sharing my page because this is what I've posted, and I'm going to get down to some of these. Okay. So this is, I'm going to show you this. These are still photos from KTLA 5, where you can see this kind of standoff here between, on the left, the resistors in a line of ice. You can see the tear gas in this photo. You can see the fields. You can see more protesters here, right? I'm going to show you now. This is an image where children and protesters are running from the tear gas.
Do not panic. Do not run. Do not run. Stay calm. They took your mom?
Okay, there is more. Sorry. I was trying to, I don't want to share that screen. I want to go back. I apologize. I want to go back to this page where I can share one more example with you from what I was watching in the middle of the night here. Here we go. Okay, let me just scroll down here to show you. This is a guy talking about what happened. Here we go.
Called Glass House Brands. Federal agents backed by National Guard showed up and raided the place. According to them, they had a warrant. Makes sense because, remember, weed farms are technically not legal in the U.S. federally, even though they're legal in California. So they've become easy targets for the feds. The first people to show up were families. You can see in the early videos, there were kids, there were family members and spouses trying to find out where their loved ones are.
That's because of you guys taking the parents away for no reason.
In another scene, a kid's walking away on the phone crying because he took to his mom and trying to talk to somebody. As that happened, agents unloaded with pepper bullets and tear gas. The scene was chaotic and it made waves, attracting even more community to come out. There's other videos showing kids running into the fields away from the tear gas and the bullets. Just to be clear, the National Guard and the federal agents fired on families with children and spouses who were asking where their loved ones are. From there, things got chaotic. People were trying to block the exits to prevent ICE agents from leaving. And you can see in videos that when they were leaving with their minivans, people started throwing rocks and breaking the windows, really angered at the situation. There was even a helicopter video where one person was caught with a gun shooting back. That's dangerous. Nobody should be doing that. Congressman Saul Carvajal showed up to try to get access, but he was denied by soldiers. And over in Oxnard, ICE agents were trying to get into the hospital. It appears that the hospital at first locked the doors on them and weren't letting them in. Protesters showed up to protest them. It became a chaotic scene, but agents did eventually get access. They went in, they grabbed their person, got back in the vehicles, and then they left. Also, shout out to this old man. Video says Carpinteria, but I don't know if this is up there or not. But somewhere out there, He was on the road where he found himself with a military convoy behind him. He stopped his El Camino. He got out. He confronted the agents and wanted to fight them. To that old man in shorts and sandals with an El Camino, thank you. We need more folks like you. Because if that was a brown man, he would have been taken down and arrested. Well, that's it for today.
And I'm going to share with you now the owner of that farm.
A lot of people here, they're hard workers. They showed up, they handcuffed our security guards, they held people at gunpoint, they threw people on the ground and injured them, not even checking if they had documentation or anything, and said, you want to do this the hard way? You want to do this the hard way, and put their knees in their backs. They injured them. We have people at the ER right now. They took everybody from our Casitas farm and put them on a bus.
How many is that approximately?
At least 100 plus people.
Really?
Yes.
What about other employees who are not farm workers?
They have them detained as well. We have vendors on site right now that can't leave, who are just doing deliveries and have nothing to do with our farm and our employees.
Yeah.
This is a targeted attack on Glass House. This is uncalled for and unconstitutional. And
This is America happening right now. This is the Republican agenda. Okay. I got to mix it up with something positive, and that is Congresswoman Jasmine Crockett. Apparently, there's news that I don't know if she's announced it or maybe others have, but maybe she will be running for Senate for John Cornyn's seat. And Fox News is flipping out about it. So you know how much I love that. Let's play it.
A shocking poll shows Texas Democrat Congresswoman Jasmine Crockett is leading in the race for incumbent Republican John Cornyn's Senate seat. Even bigger news, though, the massive backlash over her making the Texas flood disaster all about her. Well, it's not
she
news,
didn't.
because she does that with everything.
Okay. Stop. I'm just glad that Jasmine Crockett is doing so well. Now, apparently, obviously, she'd be running as a Democrat. Apparently, John Cornyn may have a challenger for that Senate seat in the primary. Apparently, Ken Paxton, the beleaguered attorney general who was being investigated on a variety of corruption charges, you may have seen a very public announcement yesterday in social media by his wife that she was, and by the way, she's not just his wife, she's in the Texas state legislature, but that she was filing for divorce on quote unquote biblical grounds. That made people wonder because the Bible's pretty big, but it then turns out later in the news story that she was finally tired of his adultery and was going to go for the divorce. Of course, Ken Paxton wants to move on to a new chapter in his life. So this is going to be an interesting election. Now, one last thing before Crazy Town. Just like it's a rare occasion when I would have Glenn Beck, a video of him on the show, it's even more rare that I would be sharing anything from Alan Dershowitz. For those of you who have ever followed me on social media, Alan Dershowitz was my crim law professor at Harvard. And when I was assigned to his class as a 1L, I was so excited. I thought this was the best thing in the world. Actually, I don't think he was in 1L year. I'm wanting to think it was 2L year that I had crim. But at any rate, I was super psyched that I was in his class. And the deal is, no, it must have been 1L year. It doesn't matter. But the deal is he was always making all the discussions in crim law about rape. And he was very much interested in eradicating the concept of date rape. And it was everything he talked about. It was very triggering and offensive. And that our final exam, which you can still see on Harvard website, is really disgusting. But anyway, Alan Dershowitz, as you know, he has been previously named as a friend of Jeff Epstein. He claimed that he got a massage but kept his underwear on, and the woman who gave him the massage was an elderly lady. Well, right now, Alan Dershowitz is claiming that, Pam Bondi and I guess Donald Trump are hiding information they should disclose basically client list information. Let's listen to this.
So let me tell you, I know for a fact documents are being suppressed, and they're being suppressed to protect individuals. I know the names of the individuals. I know why they're being suppressed. I know who's suppressing them, but I'm bound by confidentiality from a judge and cases, and I can't disclose what I know. But I hand to God, I know the names of people whose files are being suppressed in order to protect them, and that's wrong.
So where do we go with this? I don't know. Friends, it is now time for Crazy Town. And next week, I'm hoping we can get to some prism, because I think it's really important to talk about our physical health, our relational health, our intellectual health, our spiritual health, and our mental health. I want you to think about it, focus on one aspect or many of them. I'm going to come back on Monday, rejuvenated, and tell you some ideas I have in that regard. But now it is time for Crazy Town. Here we go. Today's Crazy Town comes from a Republican member of Congress defending Donald Trump and his failure to end the war that Russia brought against Ukraine. Remember, Donald Trump said he was going to end that war on day one. I don't know if you noticed, it ain't day one anymore. It's not. We're actually getting into, January 20th, February, March, April, May, June. We're getting close to 6 months in right now. And that war is raging on. So I want you to hear Ryan Zinke, former member of the Trump administration, now member of Congress, respond to questions from Wolf Blitzer. And this is crazy. We'll talk on the other side.
Former Vice President Mike Pence call out what he says are the isolationist voices surrounding the president right now. He says they've lost their footing. What's your reaction to that?
Well, I think he's actually correct. Trump had to move, I think, in Iran. And he's been very clear, no nuclear weapons in Iran, and to continue to develop and enrich uranium. I think he's very, very frustrated with the Ukrainian. Remember the campaign promise, I'm going to end it at day one. Obviously Putin is the aggressor, and Putin has not been, I would say, fair, nor has he been honest with President Trump. A lot of rhetoric, but nothing is actually happening on the ground. Putin continues to be the aggressor. And look, in June, they had more casualties in June than the last 3 years. So it looks like, they continue to mount mass offenses. Ukraine's doing a pretty good job.
I want you to hear this part again. He waffles on this. Listen.
Weapons in Iran, and to continue to.
Your reaction to that?
Here.
Well, I think he's actually correct. Trump had to move, I think, in Iran. And he's been very clear, no nuclear weapons in Iran, and to continue to develop and enrich
I want to get to the Ukraine part.
I think he's very, very frustrated with the Ukrainian. Remember the campaign promise, I'm going to end it at day one.
He's very frustrated with the Ukrainians. Remember Donald Trump's campaign promise, I'm going to end it on day one. So first of all, why would he be frustrated with the Ukrainians? They're just trying to defend their country. Then he just pivots. You heard him pivot to, well, Putin's really been more of the aggressor. Where is the Donald Trump was an idiot for thinking that he was going to end this war on day one? Where is the he has been a failure? Where is the whiteboard? Let's look at the whiteboard. Remember I told you when Donald Trump took office that someone should bring out a whiteboard every week? Here's a whiteboard. I don't bring it out every week, but here is what we have. You can see this, okay? These were the top things Donald Trump said he would work on. Number one, grocery. Our grocery prices have not gone down. Number two, immigrants. Well, by the way, I decided to make a list of both the positive things he promised and the negative things we don't want to have happen. You will see anything good he has not accomplished. Anything negative He has. So he thought he would help us with lowering grocery prices. He has not. He threatened to crack down and begin a massive deportation of immigrants. He has done that. That is something bad. Cut taxes for billionaires and corporations. Yes, that is a bad thing, and he is doing it. Are personal taxes making them go down? No, that is not what will happen under this terrible bill. What about January 6th? Another bad thing. He promised to pardon all the people who attacked the Capitol. He did that. Now they're free. Enemies list. Remember, he said he was going to go after his enemies? Yes, he has. People seem surprised by that. He is fulfilling that bad campaign promise. And the positive thing, ending wars? No, he has not done that. Later, he had earlier promised that ISIS would be or was 100% gone. Not the case. So as you can see, Donald Trump is fulfilling the campaign promises designed to hurt people and help the super wealthy and giant corporations. That's what he's doing. And the only times when he doesn't help the super wealthy and corporations is when they won't bow to his whims. That is where we are right now. Last thing, I think Philip raised it. Remember when Donald Trump announced the tariff on Brazil because he wants to pressure Lula's administration into dropping the case against Bolsonaro for the coup, the attempted coup? What people have noticed is that hours before Donald Trump made that announcement, there was someone who made a boatload of money, and basically making a trade about the relative values, I think, of the Brazilian currency. It's complicated, but the bottom line is there's only one way that someone would have put that much money down and cleaned up that much, and that is because they had information either given to them deliberately from Donald Trump or leaked by someone around him, and they are cashing in on the chaos. That's where we are. Anyway, have a fabulous weekend. Thank you. Thank you, as always, for joining me. And that is it.
Hello, prison mates. It's the Gen Taub Show. Well, welcome everyone. Let's learn about what is happening in politics yesterday and today. There was hope, and we are together in this democracy we work for. And again, welcome to the Gen Taub Show. Hello, prison mates. It's the Gen Taub Show. Well, welcome everyone. Let's learn about what is happening in politics yesterday and today. There was hope, and we are together in this democracy we work for. And again, welcome to the Gen Taub Show.